The lawyer's voice was steady when she told me, but I could hear the weight behind the words. Your stepmother has filed a will contest. She's challenging the validity of your father's estate plan. I was sitting in my car outside the grocery store when the call came. I'd been picking up things for dinner. Normal Tuesday afternoon. Normal routine. And then nothing was normal anymore. I asked what grounds she was contesting on. The lawyer said all of them. Lack of capacity. Undue influence. Fraud. Improper execution. Duress. Every possible legal challenge you could bring against a will, Patricia had filed. I asked what that meant for the estate. The lawyer said everything was frozen. The house couldn't be transferred. The accounts couldn't be distributed. Nothing could move forward until the contest was resolved. Which could take months. Maybe a year. I sat there holding my phone, groceries getting warm in the back seat, and I tried to process what I was hearing. My father had been dead for 6 weeks. 6 weeks since the funeral where Patricia had cried beside me. Where she'd held my hand during the service. Where she'd said we'd get through this together. Where she told me I was like a daughter to her. And now, 6 weeks later, she was claiming my father's will was invalid. That he hadn't known what he was doing when he signed it. That I'd manipulated him. That the entire document was fraudulent. The lawyer asked if I was still there. I said yes. She said we needed to meet. That I should bring any documents I had related to the estate. Any communications with my father. Anything that might be relevant. I said I'd be there tomorrow. Then I sat in that parking lot for 30 minutes trying to understand how the woman who'd promised to take care of me had decided to destroy me instead. My father's will wasn't complicated. It was thorough. Specific. Written with the help of an estate attorney he'd worked with for years. The house, the one he'd owned for 20 years before he ever met Patricia, went to me. The retirement accounts, the ones he'd built over a 40-year career, were split 50-50 between me and Patricia. His life insurance, with me as the beneficiary since I was a child, remained unchanged. Patricia received the house they'd bought together during their marriage. Half his retirement savings. And a stipend from a trust to cover expenses for 5 years. It wasn't 50-50. But it was fair. It reflected that I'd been his daughter for 32 years and Patricia had been his wife for 5. That he wanted to provide for her without erasing me. He'd explained it to both of us. 2 years before he died. Sat us down in the living room and walked through every provision. Why he'd structured things this way. What he wanted each of us to have. What his intentions were. Patricia had nodded. Said she understood. Said it was more than fair. Said she just wanted to make sure we were both taken care of. I'd believed her. Trusted that she meant it. That she understood my father's reasoning and respected it. Now, reading the contest filing, I understood differently. Patricia hadn't agreed with the will. She just agreed not to argue about it while my father was alive. But the moment he died, the moment there was no one left to explain or defend his choices, she'd filed. And her filing claimed something that made my stomach turn. That my father had lacked the capacity to make these decisions. That his mind had been failing. That I'd taken advantage of his decline to manipulate the will in my favor. Every word was a lie. But lies, when filed in legal documents with a lawyer's signature, become claims that have to be defended against. And defending against lies meant proving truth. Which meant I needed evidence. I called Richard Morrison the next morning. He'd been my father's estate attorney for 15 years. Had drafted the will Patricia was now contesting. I told him about the filing. He was quiet for a moment. Then he said he'd been expecting it. I asked what he meant. He said Patricia had called him 3 weeks after my father's funeral. Asked about the will. Asked if there was any way to change the distribution. If my father had ever expressed different wishes. If there were grounds to argue the document didn't reflect his true intentions. Richard had told her no. The will was clear. It had been executed properly. And my father had been very specific about his wishes. Patricia had thanked him and hung up. Richard said he'd made notes of the conversation. Documented it. Because in his experience, when someone starts asking those kinds of questions, a contest usually follows. I asked what we were dealing with. He said Patricia's filing claimed 5 things. 1. That my father lacked testamentary capacity when he signed the will. 2. That I'd exerted undue influence over him. 3. That the will contained fraudulent provisions. 4. That it hadn't been properly executed. And 5. That my father had been under duress. Each claim required proof. And if Patricia could prove any one of them, the will could be invalidated. Then the estate would be distributed according to state intestacy laws. Which, since Patricia was his surviving spouse, would give her significantly more. Potentially everything. I asked how we defend against this. Richard said with evidence. And then he said something that changed everything. Your father prepared for this exact scenario. 2 years ago, when we drafted this will, he asked me what would happen if someone tried to contest it. I told him the grounds they'd use. And he made sure we had documentation to defeat every single one. Richard pulled a file from his cabinet. Thicker than I'd expected. He set it on the desk between us. He said my father had been methodical. That after his first wife, my mother, had died, he'd seen estate disputes in his grief support group. Families torn apart over wills. Children and new spouses fighting. And he decided he wouldn't let that happen to us. So when he remarried Patricia, he'd updated his estate plan. But he hadn't just written a will. He'd created a system. A framework of documentation that would protect his wishes even if someone challenged them. Richard opened the file. Inside were 5 separate sections. Each labeled. Each containing documents I didn't know existed. The first section was labeled Testamentary Capacity. Richard explained. This was proof that my father had understood what he was doing when he signed the will. That his mind had been sound. That he'd had the legal and mental capacity to make these decisions. He pulled out a document. A cognitive evaluation from a geriatric psychiatrist. Dated 1 week before the will was signed. My father had voluntarily undergone testing. Memory assessment. Executive function evaluation. Decision-making capacity analysis. The results were clear. No cognitive impairment. No signs of dementia or decline. Full capacity to make legal and financial decisions. I asked why he'd done this. Richard said because he was smart. He knew that capacity challenges were the most common way to invalidate a will. So he'd gotten ahead of it. Documented his mental state before anyone could claim it was compromised. The evaluation was signed by a licensed psychiatrist. It included test scores, clinical observations, a detailed analysis, and a conclusion that was medically and legally bulletproof. Patricia could claim my father didn't know what he was doing. But the medical record said otherwise. That was document number 1. The second section was labeled Freedom from Undue Influence. Richard explained that undue influence was the claim that someone had manipulated or coerced my father into writing the will a certain way. That I'd controlled him. Isolated him. Pressured him into favoring me. It was one of the hardest claims to prove. But also one of the hardest to defend against. Because it relied on perception. On whether my father had been free to make his own choices. Richard pulled out another set of documents. Affidavits from 3 independent witnesses. People who'd known my father well. Who'd spent time with him during the period when the will was drafted. Who could attest to his independence and state of mind. The first affidavit was from his primary care physician. Dr. Vincent had treated my father for 12 years. The statement said my father had never shown signs of being controlled or manipulated. That he'd made his own medical decisions. That he'd been clear-minded and independent. The second affidavit was from his financial advisor. Someone who'd met with my father quarterly to review investments and retirement planning. The statement said my father had always made his own financial decisions. That he'd never seemed influenced by outside pressure. That the estate plan he described matched the will that was eventually written. The third affidavit was from a family friend. Someone who'd known my father since before my mother died. Who'd watched him navigate grief, remarriage, and blending of family. The statement said my father had talked openly about wanting to provide for both Patricia and me. That he'd been thoughtful about how to structure things fairly. That he'd never expressed feeling pressured by anyone. 3 independent witnesses. None of them related to me. None of them beneficiaries of the will. All of them willing to testify that my father had been free to make his own choices. And all of them documented in sworn affidavits signed 2 years ago. Before my father died. Before Patricia filed her contest. Before there was any dispute to influence their memories. That was document number 2. The third section was labeled Authenticity and Intent. Richard explained that fraud claims argued the will contained provisions the deceased never actually agreed to. That signatures were forged. That language was added without consent. That the document didn't reflect actual wishes. My father had anticipated this too. Richard pulled out a USB drive. On it was a video recording. Dated the same day the will was signed. Filmed in Richard's office. I'd never seen it before. Richard played it. The video showed my father sitting at the conference table. Alert. Calm. Composed. Richard's voice off camera asked him to state his name and the date. My father did. Then Richard asked a series of questions. Do you understand that you're here today to sign your last will and testament? My father said yes. Have you read the will and do you understand its contents? Yes. Does this will reflect your wishes for how your estate should be distributed after your death? Yes. Are you signing this will of your own free choice, without pressure or influence from anyone? Yes. Is there anything in this will that you don't understand or didn't intend? No. This is exactly what I want. The video continued. Richard asked my father to explain, in his own words, why he'd structured the will the way he had. My father looked directly at the camera. He said he wanted to provide for Patricia. That she'd been a good partner during their marriage. That he wanted her to be financially secure. But he also said the house that would go to me had been in our family for decades. That it had been my mother's house. That he wanted me to have it because it connected me to her memory. He said the retirement accounts would be split because Patricia deserved to benefit from the years they'd been married, but I deserved to benefit from the lifetime I'd been his daughter. He said he'd thought carefully about this. That it was fair. That it was final. Then he signed the will on camera. With Richard and 2 witnesses present. All of them visible in the frame. The entire execution documented. Time-stamped. Recorded. Patricia could claim the will was fraudulent. But the video showed otherwise. That was document number 3. The 4th section was labeled Proper Execution. Richard explained that wills have to be executed according to specific legal requirements. Signed by the testator. Witnessed by at least 2 people who aren't beneficiaries. Notarized in some states. If any of those requirements aren't met, the will can be invalidated. Even if everything else is correct. Patricia's contest claimed the will hadn't been properly executed, that the witnesses weren't independent, that the process had been rushed, that legal formalities hadn't been followed. Richard pulled out his supervision notes. A detailed record of the will execution. It documented everything. The date and time the will was signed. The names of the two witnesses. Their relationship to my father, which was none. They were paralegals from Richard's firm who'd never met my father before that day. The document showed that Richard had explained each provision of the will to my father before he signed. That my father had asked questions. That Richard had answered them. That my father had confirmed he understood everything. It showed that the witnesses had watched my father sign. That they'd signed immediately after. That a notary had been present and had notarized the document. It showed that my father had been given a copy of the will. That he'd taken it home. That he'd had the opportunity to review it and come back with changes if he wanted. He never did. The notes were time-stamped. Cross-referenced with Richard's calendar. Corroborated by the video recording. And they proved that every legal requirement for a valid will had been met. Meticulously. Deliberately. With documentation at every step. Patricia could claim the execution was improper. But the supervision notes showed a textbook perfect process. That was document number 4. The 5th section was different. Richard called it the enforcement mechanism. He explained that even with all the documentation, even with proof that the will was valid, someone could still contest it. Drag the estate through months of litigation. Cost tens of thousands in legal fees. Delay distribution. Create conflict. My father had wanted to prevent that. So he'd included a no contest clause. Also called an interorum clause. Richard read it aloud. Any beneficiary who contests this will, or any of its provisions, shall forfeit entirely any gift or bequest made to them herein, and shall be treated as if they predeceased the testator. In plain language, it meant if you challenged the will and lost, you got nothing. Not even what the will had originally left you. You'd be completely disinherited. It was designed to make contesting too risky. To force potential challengers to think carefully about whether their case was strong enough to risk losing everything. But there was a catch. No contest clauses weren't enforceable in every state if the contest was brought in good faith. If someone had legitimate grounds to believe the will was invalid, some courts allowed them to challenge without penalty. Richard said that's why my father had been so thorough with the other 4 documents. Because if Patricia's contest failed, if we could prove the will was valid on every ground she challenged, then her contest wouldn't be considered good faith. It would be considered frivolous. And the no contest clause would trigger. She'd lose not just the contest, but everything the will had given her. The house she was supposed to inherit. Her 50% of the retirement accounts. The trust stipend. All of it would be forfeited. And that forfeiture would flow to the residual beneficiary. Which, according to the will, was me. Richard closed the file. He said my father had built a trap. 5 layers of protection that would not only defeat a contest but would punish the person who brought it. All I had to do was use them. That was document number 5. I took the contest filing home. Read it line by line. Tried to understand what Patricia was actually arguing. The first claim was lack of testamentary capacity. It alleged that my father had been suffering from cognitive decline in the months before the will was signed. That he'd been forgetful. Confused. Unable to understand complex financial matters. That I'd taken advantage of his diminished state to secure a favorable distribution. The claims cited no medical evidence. No doctor's testimony. No cognitive testing. Just Patricia's observations that he'd seemed different and wasn't himself. It was a feelings-based argument with no factual support. The second claim was undue influence. It alleged that I'd isolated my father from Patricia. That I'd controlled his access to information. That I'd pressured him to favor me in the will. That he wouldn't have made these decisions without my manipulation. Again, no evidence. Just allegations that I'd been overly involved in his life and seemed to have too much influence over his decisions. The third claim was fraud. It alleged that the will contained provisions my father never agreed to. That I'd worked with the attorney to add language favoring me. That my father's signature might have been obtained under false pretenses. No specifics. No proof. Just suspicion. The fourth claim was improper execution. It alleged that the witnesses weren't truly independent. That the process had been rushed. That my father hadn't fully understood what he was signing. No names of witnesses. No timeline. Just vague claims about procedure. The fifth claim was duress. It alleged that my father had been under emotional pressure when he signed the will. That he'd felt obligated to favor me. That he hadn't been free to make his own choices. Every claim was nonspecific. Feeling-based. Designed to sound plausible without offering actual proof. And every single one would fail when confronted with the 5 documents my father had prepared. Patricia's attorney requested discovery. That meant both sides had to exchange documents. Financial records. Communications. Anything relevant to the contest. I turned over everything Richard had given me. The capacity evaluation. The witness affidavits. The video recording. The supervision notes. The no contest clause language. All of it. Organized. Indexed. With a cover letter explaining that these documents directly refuted each of Patricia's claims. We also requested discovery from Patricia. Asked for any evidence supporting her allegations. Medical records showing cognitive decline. Communications showing I'd isolated my father. Documents proving fraud or duress. Anything. She produced almost nothing. A few text messages between her and my father that she claimed showed he was confused. The messages showed normal conversation. A statement from a friend of hers who said my father had seemed stressed at a family gathering. No specifics about what that stress was related to. No connection to the will. And a letter from Patricia herself describing her concerns about my father's mental state. Written after he died. After the will had been read. After she knew what it said. No contemporaneous documentation. No medical opinions. No concrete evidence. Just suspicion and retroactive interpretation. Richard reviewed everything. Then he said we were in a strong position. That Patricia's claims had no evidentiary support. That our documentation was overwhelming. That we should move to dismiss the contest on summary judgment. I asked what that meant. He said it meant asking the court to throw out the case without a trial. Because even viewing the evidence in the light most favorable to Patricia, she couldn't win. Her claims failed as a matter of law. We filed the motion 2 months after the contest began. The motion for summary judgment was detailed. 60 pages. It walked through each of Patricia's claims. And it showed, methodically, why each one failed. Claim 1, lack of capacity. Our evidence, a cognitive evaluation from a board-certified geriatric psychiatrist, conducted 1 week before the will was signed, showing full capacity. No signs of impairment. Normal test scores across all domains. Patricia's evidence, her subjective observation that my father seemed forgetful. The motion argued that subjective observations don't overcome objective medical evidence. That Patricia wasn't qualified to diagnose cognitive decline. That even if my father had occasional memory lapses, which the evaluation showed he didn't, that wouldn't rise to the level of incapacity. The legal standard for capacity is low. You just need to understand what a will is, what property you own, and who your beneficiaries are. The evaluation proved my father understood all of that. Claim 1 failed. Claim 2, undue influence. Our evidence, 3 sworn affidavits from independent witnesses, all stating my father made his own decisions and showed no signs of being controlled. Plus the video recording showing him clearly and independently explaining his wishes. Patricia's evidence, allegations that I was too involved in my father's life. No specifics. No proof of isolation or manipulation. The motion argued that being involved in a parent's life isn't undue influence. That my father had maintained relationships with multiple people, all of whom confirmed his independence. That Patricia's claims were speculation without foundation. Claim 2 failed. Claim 3, fraud. Our evidence, a video recording of my father reading the will, confirming he understood every provision, and stating it reflected exactly what he wanted. Plus Richard's supervision notes showing the entire drafting process. Patricia's evidence, suspicion. No forged signatures. No proof of altered language. Nothing. The motion argued that fraud requires proof, not suspicion. That the video made fraud impossible. Claim 3 failed. Claim 4, improper execution. Our evidence, Richard's supervision notes documenting that the will was signed in front of 2 independent witnesses who weren't beneficiaries, that it was notarized, that every legal formality was followed, and that the entire process was recorded on video. Patricia's evidence, vague allegations about the process being rushed. No specifics. No proof the witnesses were compromised. No evidence of procedural defects. The motion argued that the execution met every requirement under state law. That the witnesses were demonstrably independent. That the video showed a careful, unhurried process. That Patricia's allegations were baseless. Claim 4 failed. Claim 5, duress. Our evidence, the video recording where my father explicitly stated he was signing the will of his own free choice, without pressure from anyone. Plus affidavits from witnesses who'd spent time with him and saw no signs of stress or coercion. Patricia's evidence, her feeling that he'd seemed obligated to favor me. The motion argued that duress requires proof of threats or coercion. That feeling obligated to provide for your daughter isn't legal duress. That my father's video statement directly contradicted any claim of pressure. Claim 5 failed. The motion concluded that Patricia had failed to produce evidence supporting any of her claims. That all 5 were contradicted by clear, contemporaneous documentation. That the contest should be dismissed. And that because the contest was frivolous, brought without good faith basis, the no contest clause should be enforced. Stripping Patricia of everything the will had left her. We attached all 5 documents as exhibits. Filed the motion. And waited for the court to respond. Patricia's opposition to our motion was filed 3 weeks later. It was shorter than our motion. Less detailed. And it didn't really address the evidence. Instead, it made emotional arguments. That Patricia had been my father's wife. That she'd cared for him during his illness. That she deserved to inherit more than what the will provided. That my father must have been influenced because he'd once told her he'd take care of her. None of that was legally relevant. The question wasn't what was fair or what Patricia felt she deserved. The question was whether the will was valid. And on that question, Patricia's opposition offered almost nothing. It argued that the cognitive evaluation wasn't conclusive. That one test couldn't prove capacity for all time. That my father could have declined after the evaluation. But it offered no evidence of decline. No medical records. No testimony from doctors who treated him after the evaluation. Just speculation. It argued that the witness affidavits were biased. That the witnesses were my father's friends and would naturally support his decisions. But it didn't explain how that made them biased. And it didn't offer any counter-testimony from witnesses who'd seen something different. It argued that the video was staged. That my father had been coached on what to say. But it offered no proof. No expert analysis. No evidence the video had been edited or manipulated. Just an assertion. It argued that the supervision notes were self-serving. That of course Richard would document everything perfectly because he drafted the will. But it didn't point to any actual defect in the execution. Any witness who wasn't independent. Any formality that wasn't followed. The opposition was argument without evidence. Emotion without proof. And Richard said it was exactly what he'd expected. Because when you have no case, all you can do is throw doubt and hope something sticks. The court scheduled a hearing on our motion. Both sides would present arguments. The judge would ask questions. Then she'd decide whether to dismiss the contest or let it proceed to trial. We arrived early. Patricia was already there with her attorney. We didn't speak. Didn't acknowledge each other. Just sat on opposite sides of the courtroom waiting. The judge called the case. Asked Richard to present our argument. Richard stood. He didn't speak long. He simply pointed to the 5 documents. He said Patricia's contest alleged 5 defects in the will. And we'd produced 5 documents that directly refuted each allegation. He walked through them briefly. The capacity evaluation. The witness affidavits. The video recording. The supervision notes. The no contest clause. He said these weren't documents created after the fact to defend against a contest. They were documents created 2 years ago, as part of the original estate planning process, to protect against exactly this kind of challenge. He said Patricia had produced no evidence to overcome any of them. That her contest was based entirely on speculation and feeling. That it failed as a matter of law. And that because it was brought without good faith basis, the no contest clause should be enforced. The judge asked Patricia's attorney to respond. He stood. Made the same arguments that were in the written opposition. That the evaluation wasn't conclusive. That the video could have been staged. That the witnesses might be biased. The judge interrupted. Asked if he had any evidence to support those claims. He said no, but discovery was ongoing. The judge asked what specific evidence he expected to find. He said he wasn't sure yet. The judge asked if he had any medical expert who would testify that my father lacked capacity. He said no. Any witness who would testify to undue influence? No. Any forensic analysis showing the video was manipulated? No. Any proof the execution was improper? No. The judge closed her notebook. The judge issued her ruling from the bench. She said she'd reviewed the motion, the opposition, and all the exhibits. That she'd watched the video recording. Read the capacity evaluation. Reviewed the witness affidavits and supervision notes. She said Patricia's contest raised 5 claims. And each claim required proof, not speculation. She went through them one by one. On capacity, the medical evaluation was clear. Conducted by a qualified expert. Showing no impairment. Patricia's subjective observations didn't overcome that. On undue influence, the witness affidavits and video showed independence. Patricia had offered no evidence of isolation or manipulation. On fraud, the video made clear my father understood and agreed with every provision. There was no evidence of forgery or deception. On improper execution, the supervision notes documented perfect compliance with legal requirements. No defect had been identified. On duress, the video showed my father explicitly stating he was acting freely. No evidence of coercion had been presented. The judge said that even viewing the evidence in the light most favorable to Patricia, she couldn't prevail on any claim. That the documentation was too strong, too contemporaneous, too thorough. She granted our motion for summary judgment. The contest was dismissed. Then she addressed the no contest clause. She said the clause was enforceable under state law if the contest was brought in bad faith. That bad faith meant filing without reasonable grounds to believe the will was invalid. She said Patricia had to have known, or should have known, that her claims had no evidentiary support. That she'd filed anyway, hoping to pressure a settlement or create delay. That constituted bad faith. The no contest clause was triggered. Patricia's inheritance under the will was forfeited entirely. All of it would pass to the residual beneficiary. Me. The hearing was over in 40 minutes. The order was filed 2 days later. The contest was dismissed with prejudice, meaning it couldn't be refiled. The no contest clause was enforced. Patricia's forfeiture was complete. The house she was supposed to inherit went to me. Her 50% of the retirement accounts went to me. The trust stipend went to me. Everything the will had left her was gone. Because she'd challenged the will and lost. Richard explained what happened next. The estate would be distributed according to the will as modified by the forfeiture. I would receive the house my father had left me, plus the house Patricia had been supposed to receive, plus 100% of the retirement accounts instead of 50%, plus the trust. Minus estate taxes and attorney fees, I'd inherit roughly 90% of my father's estate. Patricia would receive nothing. Not because my father had wanted to disinherit her, but because she'd gambled that his planning wasn't as thorough as it was. And she'd lost. I asked if she could appeal. Richard said technically yes. But appeals courts rarely overturn summary judgment when the evidence is this one-sided. And even if she did appeal, she'd already triggered the no contest clause. The forfeiture was final. She could spend years in appellate court, and even if she won, which was unlikely, she'd still get nothing. The no contest clause didn't depend on the outcome of appeals. It triggered the moment she filed the contest. And once triggered, it was permanent. Patricia had destroyed her own inheritance. Not because I'd manipulated anything, but because my father had prepared for exactly what she did. And his preparation had worked perfectly. I went back to Richard's office a week after the ruling. I wanted to understand something. I asked why my father had been so thorough. Why he'd gone beyond just writing a will. Why he'd created this entire system of documentation. Richard said my father had told him something during their first meeting after he'd remarried. He'd said he loved Patricia. That she was a good partner. That he wanted to provide for her. But he'd also said he'd seen what happened in blended families. How new spouses and children from previous marriages could end up in conflict. How people fought over estates not because they were greedy but because they felt entitled to more than they'd been given. He'd said he didn't want that for us. Didn't want Patricia and me fighting over his money after he was gone. So he'd asked Richard to build something that would prevent it. Richard had explained the 5 common grounds for will contests. Capacity, influence, fraud, execution, duress. And my father had systematically eliminated each one. Got the capacity evaluation to prove his mind was sound. Secured the witness affidavits to prove his independence. Recorded the video to prove his intent. Documented the execution to prove it was proper. And included the no contest clause to make challenging too risky. Richard said my father had understood human nature. That if someone was going to contest, they'd do it whether the will was fair or not. Because fairness is subjective. What seems fair to you might seem unfair to someone else. So he didn't try to prevent challenges by being more generous. He prevented them by making challenges unwinnable. By creating documentation that was so thorough, so clear, so contemporaneous, that no contest could succeed. And by making failure catastrophic. The no contest clause meant Patricia had to be absolutely certain she'd win before filing. She wasn't certain. She just hoped. And hope wasn't enough against documentation. I thought about what the judge had said during the hearing. That Patricia's claims failed because she couldn't meet the 5 requirements. The 5 legal standards for invalidating a will. I'd learned them through this process. Through watching Patricia try and fail to prove each one. Requirement 1, to prove lack of capacity, you need medical evidence. Actual doctors. Actual diagnoses. Actual proof that the person didn't understand what they were doing. Subjective observations aren't enough. Feelings aren't enough. You need objective medical documentation showing impairment at the time the will was signed. My father had preempted that with his evaluation. Requirement 2, to prove undue influence, you need evidence of control. Isolation. Manipulation. Specific acts that show the person wasn't free to make their own choices. Just being close to someone isn't influence. You need proof they were dominated. My father had preempted that with independent witnesses who confirmed his autonomy. Requirement 3, to prove fraud, you need evidence of deception. Forged signatures. Altered language. Proof that the document doesn't reflect what was actually agreed to. Suspicion isn't enough. You need concrete proof of falsification. My father had preempted that with the video recording. Requirement 4, to prove improper execution, you need evidence of procedural defects. Witnesses who were beneficiaries. Missing signatures. Failure to follow legal formalities. Vague allegations aren't enough. You need specific defects. My father had preempted that with perfect documentation of the execution process. Requirement 5, to prove duress, you need evidence of coercion. Threats. Pressure. Proof that the person was forced to sign against their will. Emotional obligation isn't duress. You need actual coercion. My father had preempted that with his video statement of free choice. 5 requirements. 5 types of proof needed. And 5 documents that made providing that proof impossible. That was the system my father had built. Not just a will, but a fortress around his will. I started researching estate planning after everything was finalized. Not because I needed to plan my own estate yet, but because I wanted to understand what my father had done and why it worked. I learned that most wills don't have this level of protection. People write wills, sign them, file them away, and assume that's enough. But a will is just a document. And documents can be challenged. What makes a will defensible isn't just what it says. It's what supports it. The documentation around it. The proof that it's valid. My father had understood that. Had known that writing a fair will wouldn't prevent challenges. That even if his distribution was reasonable, someone might still contest. So he'd built proof into the process. I learned that the 5 documents he'd created weren't unusual individually. Lots of estate attorneys recommend capacity evaluations for older clients. Lots of people get witness affidavits. Some people record their will signings. But having all 5, created contemporaneously, as part of a coordinated plan, was rare. Most people don't think that far ahead. Don't anticipate conflict before it happens. Don't prepare for challenges that might never come. My father had. And that preparation had saved his estate. Saved me from years of litigation. Saved his wishes from being rewritten by a court. I learned that no contest clauses are powerful but underutilized. Many people don't include them. And many who do include them don't pair them with enough documentation to make them enforceable. Because a no contest clause only works if the challenge fails. And challenges only fail if you have proof the will is valid. My father had both. The clause and the proof. That combination made his estate plan essentially bulletproof. When the estate was finally settled, when everything had been distributed and the accounts closed, I kept copies of the 5 documents. Not in a safe deposit box. In a file at home where I could access them easily. Because they weren't just proof that my father's will was valid. They were a template. A guide for how to protect my own estate planning when the time comes. Document 1, the capacity evaluation. I learned you can request this from a geriatric psychiatrist or neuropsychologist. It costs about $1,500. Takes 2 to 3 hours. And it creates a medical record of your mental state at a specific point in time. If you ever update your will, especially as you get older, having a recent capacity evaluation makes it nearly impossible for someone to claim you didn't know what you were doing. Document 2, the witness affidavits. I learned these can come from anyone who knows you well and can speak to your independence. Your doctor. Your financial advisor. Close friends. The affidavits should state that you make your own decisions, that you're not being controlled by anyone, and that you've discussed your estate planning wishes openly. Document 3, the video recording. I learned most estate attorneys will record will signings if you ask. Some do it routinely. The video should show you reading the will, confirming you understand it, explaining why you've made your choices, and signing it in front of witnesses. It should be clear, unedited, and dated. Document 4, the supervision notes. I learned this is just the attorney documenting the entire process. Who was present? What was discussed? What questions were asked? What formalities were followed? Good attorneys do this anyway. But you can request a detailed memo memorializing the execution. Document 5, the no contest clause. I learned this should be included in every will unless you have a specific reason not to. The language is simple. Any beneficiary who contests forfeits their inheritance. It makes people think twice before filing. 5 documents. 5 layers of protection. And together, they make your will almost impossible to successfully challenge. Patricia didn't appeal the ruling. Didn't file any further motions. Just accepted the judgment and disappeared from my life. I heard through mutual acquaintances that she'd moved to a different state. Sold the house she and my father had bought together. Started over somewhere else. I don't know if she regretted filing the contest. If she wished she'd accepted the original distribution. If she understood that by trying to get more, she'd ended up with nothing. I suspect she convinced herself she'd been wronged. That the system had failed her. That my father's documentation was somehow unfair. People rarely accept responsibility for strategic mistakes. It's easier to blame the outcome than the decision. But the outcome was clear. My father had left her 50% of his retirement accounts, a house, and a trust stipend. Probably $400,000 total. She'd gambled that she could invalidate the will and get more. That gamble cost her everything. And it wasn't because I fought dirty. It was because my father had prepared thoroughly. Had anticipated exactly what Patricia did. And had built protections that made her challenge unwinnable. The forfeiture wasn't cruelty. It was consequence. The natural result of challenging a will that was designed to withstand challenge. She'd thought she could break it. She'd been wrong. And the 5 requirements, the 5 types of proof she couldn't produce, had proven her wrong in court. Permanently. Expensively. Completely. I visit my father's grave sometimes. Sit there quietly. Tell him about the case. About how his planning worked. About how the 5 documents defeated every challenge. about how the no contest clause did exactly what it was designed to do. I thanked him for being thorough, for anticipating conflict, for protecting both his wishes and my inheritance, for understanding that love isn't enough, that good intentions don't prevent disputes, that the only thing that matters after you're gone is what you documented while you were alive. Patricia thought she could break the will. She thought my father's planning was just paper, that emotion and need would overcome documentation, that a judge would see her side and redistribute the estate more favorably. She'd been wrong about all of it. Because breaking a will requires meeting 5 legal requirements: proving lack of capacity, proving undue influence, proving fraud, proving improper execution, proving duress. And my father had made meeting those requirements impossible, with 5 documents created specifically to defeat each challenge. A medical evaluation proving capacity, witness affidavits proving independence, a video recording proving intent, supervision notes proving proper execution, and a no contest clause making failure catastrophic. She couldn't break the will because my father had built it to be unbreakable. Not through generosity, not through fairness, through preparation, through documentation, through understanding that estate planning isn't just about what you want to give people. It's about protecting those wishes from people who'll want to change them after you're gone. I inherited my father's house, his retirement accounts, his careful planning, and the lesson that documentation defeats emotion every time. Patricia thought she could break the will. I showed her the 5 requirements she couldn't meet. And the will, along with everything it protected, stood exactly as my father had written it. Not because he was luckier or smarter than other people, but because he'd prepared for the challenge before it came. And preparation, when thorough enough, is indistinguishable from invincibility.